rise. The Court of Appeals, Division 1 is now in session.
Be seated. Good morning. Now is the time set for oral argument in cause number 1CA-CV17-0381. The case is titled Ironwood Commons Community Homeowners Association, Inc. versus Shannon K. Randall. These proceedings are being both audio and video recorded this morning, so barring any unforeseen problems, you get to see yourself on YouTube in a couple of weeks. We'd invite you to do that. We need to get our viewership up. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. However, ultimately, your reserving of rebuttal time will be up to you. We have reviewed the briefs and conferenced the case this morning. We are well aware of the facts and the issues attendant to this argument. We tell you that so you can keep it in mind and couch the way you address your argument accordingly. When you come to the podium, I would ask that each of you state your name and who you represent. And with that, appellant's counsel, you can begin.
Good morning. Douglas Wigley on behalf of Shannon Randall, the appellant in this matter. May it please the court. The primary issue in this case is a very narrow one. Specifically, the court needs to decide what county clerk is the proper one to file an affidavit of judgment renewal with pursuant to ARS 12-1612A. Now, that statute requires an affidavit of renewal to be filed with the, quote, clerk of the proper court. Now, is that clerk the one in the county where the judgment originated from? Or is it a clerk in one of the 14 other counties where the judgment debtor may have taken that judgment and filed it as a transcript judgment?
Counsel, do all the parties agree that when it says file it in the proper court, we don't have a statute that says that the proper court is the superior court in the county from which the non-record court entered the order? You understand what I'm saying?
I think so. I think
we don't have anything that says that if you want to record that judgment, if you're in Coconino, if the justice court there is in Coconino County, then the judgment has to be recorded in Coconino County. We don't have that, do we? It just simply says the superior court. Is that not correct?
It says the clerk of the proper court.
Okay. So does it say the clerk of the court in which the underlying judgment was entered?
No, it does not say that.
Okay, so we're working with an unknown.
Absolutely, Your Honor. And the court has addressed that phrase, clerk of the proper court, in the J.C. Penney v. Lane case. The facts are similar, though there is a distinction here. But when you look at the rationale in that J.C. Penney case and you apply it to these facts, the conclusion needs to be the same, in that the proper court, or the clerk of the proper court, is the clerk in the county where the judgment originated from.
Originated, or where the judgment was initially recorded?
Originated from, where it came from.
And we know that because?
Because the purpose behind the renewal statute is to provide some form of notice to the judgment debtor or other interested parties, like other creditors, that the status of the judgment, is it still being pursued? And the judgment debtor has noticed that the judgment came from in this case, the Casa Grande Justice Court. She knew that it came out of Pinal County. What the judgment debtor does not know is that here, the party, or in any transcript judgment proceeding or TJ proceeding, that the party took it to another county and TJ'd it in that county. And that's because the transcript judgment procedure is this very simple administrative procedure where you just get a certified copy, you file it in a different Superior Court county, and you get a new case number. There's zero obligation or requirement that you give notice to the judgment debtor that you've now taken this judgment to another county.
With that being said, why does it matter then if it's Pinal County or Pima County? How does that help the debtor have notice if there's no notice requirement associated with the affidavit of renewal? You don't have to provide, or when filing the transcript of judgment. So how is your client worse off the fact
that the affidavit was done in
in
Maricopa rather than
County?
Pinal?
Yeah, exactly.
Right. No, the protection for the debtor, the requirement that it be done in the proper court, it's limited. But it clearly is the proper court. It's a singular court. And in JCPenney, in that case, they said that the judgment debtor has the obligation to check the records in the court that she knows about, which in this case would be Pinal County. But in JCPenney, this court expressly said she does not have the obligation to go look at the records from 14 other counties. And that's exactly what Ironwood Commons would have this court approve, is that we can go take this judgment, go TJ it in any other county. We don't have to give her any notice that we're there, and then we can do the affidavit of notice in any of those other counties. So what you're doing is you're requiring the judgment debtor to scour all 15 counties.
But this judgment was originally filed in Maricopa County, correct?
No, they sued her in Casa Grande Justice Court. And then they filed it as a transcript judgment in Maricopa County, yes.
Did she have notice of that?
No.
So are you saying that original one they filed in Maricopa was no good?
No, they have the right to file it in Maricopa.
But she has no notice of it. If the whole point of this is notice, she's not going to have notice of anything.
But the notice, the burden is on
her. Renewal, but she doesn't have to have notice that there's a judgment in Maricopa County?
No, she doesn't have. The notice requirement is that she's on notice that she has to check one proper court records. And which court does she have to check? Is it the court where the judgment originated from, or is it any of the other courts? And it's too much of a burden to put on the judgment debtor to make her go check 15 other courts. And that express language is stated in the JCPenney case.
Counsel, you keep using the word proper court, and I do understand where that comes to play, okay? But could proper court simply be an extension of the earlier comment that it needs to be recorded in the superior court? And it never says the superior court where the underlying judgment, in the county in which the underlying judgment was obtained. So by being the proper court, how is that not just in the superior court, which would be the proper court for filing that?
Right. In Arizona, as discussed in the JCPenney case, I mean, it is a unified court. It's the Superior Court of Arizona. The statute, though, the renewal statute at 1216.12a says it needs to be filed with the clerk of the proper court. And this court in JCPenney interpreted that to mean that the legislator intended that by identifying the clerk in the statute, that the legislature was referring to a specific county, because there are 15 different clerks of court.
Exactly. I mean, to record it, you're going to take it to the clerk of the court, and every county has a clerk of the court. In fact, you have clerks at different levels of the court, but I think we're all agreeing that it's a superior court, so it's the clerk of the superior court, right?
Right, and there's 15 different clerks of the superior court.
So to take it to the clerk of the proper court still doesn't get us into a vein where we can say that clearly what the legislature intended was the clerk of the proper court being defined as the superior court in the county out of which the non-record judgment was obtained. You don't have that last part there. You don't have anything that ties the earlier part of that, clerk of the court, to of the county in which the non-record court issued its judgment. Do you?
What you have is the intention of the renewal statute is to give notice to the judgment debtor of the status of the judgment.
Then why don't we just provide that notice be provided at the time of the filing?
That would be a great idea. The legislature didn't do that.
Because we are not required to give them notice, but you're saying that this guarantees that they have notice.
If they file it at least in the court where the judgment came from. I mean, if we let the judgment debtor go and pick any other court, I mean, then they can play this game where they go to some distant county and do the affidavit there or a TJ there, and the judgment debtor is then forced to guess, well, which court did they?
What's the policy? What benefit is gained? I mean, if it is gamemanship,
I don't see there's any benefit to it.
But then how is that? How, again, I go back to the question from before, how is it a detriment to the debtor? I mean, are they going to do different planning? Are they going to do something different? They're going to say, now we're off the hook. We don't have to worry about that debt. I mean, is that the reasoning? Now we're off the hook because it didn't get recorded in Pinal County.
Well, it's the legislature intended for the judgment debtor to be off the hook at the expiration of 5 years if they fail to file the affidavit.
Now 10. I'm sure you've probably heard, yeah. But
right, and that's not effective yet, and it wouldn't be retroactive.
Exactly.
It wouldn't relive an expired judgment.
Yeah. But again, so under, but like, let's turn to a different statute. 33962 talks about the process in which you present a certified transcript, how you do the TJ, right? The transcript of judge, how you do that. You have, and you file that with the clerk of the Superior Court. But it doesn't say of the county in which the judgment was issued. I mean, aren't we reading language into that, as Judge Jones suggests? Wouldn't we be reading that into the statute that doesn't exist there? It just says you can record a transcript of judgment wherever you want.
Recording is recording with the county recorder to create a judgment lien.
But once it's there, then what prevents somebody from filing an affidavit of renewal on that transcript of judgment? That's the question. That's the question that's not resolved in my mind by J.C. Penney.
Right. So I guess a way to look at J.C. Penney is, did this court in J.C. Penney say the proper court is the one where you've done a TJ proceeding, or is the proper court the one that gives notice to the judgment debtor that they intend to continue pursuit of this judgment by filing the affidavit of renewal?
But in J.C. Penney, they did exactly what I think you're saying doesn't work, which is they went into, in J.C. Penney, they started in one, the underlying judgment arose out of one county. They filed the initial, they filed the initial, they recorded the judgment in that same county, and then they tried to record the renewal outside the county.
Right.
And now that's when you get into the issue of proper court, isn't it? Where if you're going to start it in a county, you got to continue it in that county. You got to go with where the initial judgment was recorded. Isn't that right?
Well, but it's the why in J.C. Penney. It's why was filing it in Coconino County the proper court in J.C. Penney, and it's not because that's where they did a TJ. Because when they did that TJ in Coconino County, they had zero requirement to give notice to that judgment debtor that we're now taking this judgment to Coconino County Superior Court. Again, like when Ironwood filed it in Maricopa County Court under a TJ proceeding, no notice was given to Randall. But it's that judgment debtor's obligation to look to county records, the proper court. And her obligation is limited to just one court. They could have taken it and TJ'd it in any county and not given her any notice of where it is. Now she's forced to guess, well, which one would it be? And I think to go back to Judge Brown's question is, how is the judgment debtor going to plan differently? I mean, she has this statutory protection that you can't issue execution on an expired judgment, and that's exactly what happened here. 6 years after this judgment was entered, her wages started being garnished. And she did not expect that would happen after such a long period of time. And because that renewal was done in Maricopa County, where she never had any notice that this judgment had been taken to Maricopa County, she would have no reason to think, I need to go look in Maricopa County.
Counsel, the judgment and the renewal were both filed in the same county.
That's correct. And those are that's the different facts in this case versus J.C. Penney.
Why would a clerk accept a renewal in a county where they didn't have the underlying judgment? Clerk of the Superior Court. Is there any obligation on the clerk, I guess would be the better way to say it?
No, I don't think there's any obligation on the clerk. I mean, they take that document and they file it. They stamp the case number on it and file it. Whether it's effective or not, that's for the judge to determine.
To what extent did the J.C. Penney Court rely on 22246, which they cited it, but it's not clear to me to what extent they relied upon it, because that's where if you're going to take the you have to, if you're going to execute on real property, and then under those circumstances, then you have to take the transcript of judgment and file it in the county where the judgment was given. It specifically says that.
Right.
So doesn't that make this different? I mean, there's no indication on this record, I don't believe, that the creditor is trying to execute on real property in the county where the judgment was given. In other words, in Pinal County. They've never tried to execute on any real property in that county.
They recorded the judgment in Maricopa County, which
But
that's the first step to create that judgment
not
lien.
to do a sheriff's sale on
they did
real
not do that.
property.
She didn't have any real
Because
property
my
anywhere.
question is, but why would in J.C. Penney, why would the court rely upon 222-246 if that wasn't at play in that case? In other words, one would surmise that they were trying to execute on that in Coconino County, that the debtor must have had some property in Page or somewhere in the vicinity.
Well, and 22246 says that you can't foreclose over a justice court judgment unless you file it with the Superior Court in the county where the judgment was given.
Yeah.
Right.
Which we would all agree that if that would be Pinal here.
That would be Pinal here.
Under this statute, under that 22.
Under this statute. And I think, I mean, this statute, one of the reasons I think it relates to this, and I think it's a soft relationship, but is that it shows the legislature's concern with a justice court judgment being taken elsewhere. They want it to go in the same Superior Court county where the judgment was given. And that's exactly what should also happen for an affidavit of renewal, not because the express language says it. We lack this language in the affidavit of renewal statute. Instead, what we have is the clerk of proper court, which in J.C. Penney, the court said that the proper court is the one that the judgment debtor has some form of notice of. And the form of notice that she has is, this is where my judgment came from. If I want to check up on the records, I do it here. But when they TJ it in some other county, that's an ex parte proceeding. She has no notice that's going on, and she would be forced to guess what other county might it be here. And J.C. Penney expressly said you cannot be required to make that judgment debtor review the records of all 15 counties. That would defeat the intent of the renewal statute in the fact that the affidavit has to be filed in the proper court. One other item I just want to raise, and then I'll reserve the rest of my time for rebuttal, is ARS 12-1613E. It's the very next statute after the affidavit of renewal statute. It's actually a very important point here in that it expressly supports a holding here that the proper county for the affidavit of renewal is the county where the judgment originated from. What it says is that a copy of the renewal affidavit may be docketed in any other county of the state in which a transcript of the original judgment was filed. So what the legislature is saying is you go and you do your affidavit of renewal in the proper county. Then you can take that affidavit of renewal and docket it in any other county where you've done a TJ proceeding. They are not saying you do your affidavit in the other county where you're doing a TJ proceeding. You do it in the proper county, and then once you have it, you can take it anywhere else that you need to. Here, they did the affidavit renewal in the TJ county, which again, didn't give any notice to the judgment debtor that this judgment is now under proceedings in Maricopa County. She has no reason to think, I need to go look in Maricopa County. And that's the key behind the renewal affidavit statute, is to give notice to the judgment debtor that, where do I look to see if this judgment is still active?
You know, I'm just looking at our conclusion in J.C. Penney. We reversed the trial court's decision because we conclude that the statutory requirement of filing in the proper court means that if the judgment was a Coconino County Superior Court judgment, the affidavit of renewal of the judgment was not effective unless timely filed in the Coconino County Superior Court rather than the Superior Court located in some other county. What we said in the conclusion in J.C. Penney is that the problem was that they didn't renew it in Coconino County because it was originally a Coconino County Superior Court judgment. We didn't say that the renewal was ineffective because the judgment emanated from initially from a trial court in another county.
The judgment emanated from a trial court in Coconino County. But
we said the reason that the renewal was no good was because the judgment was filed in Coconino County Superior Court, not somewhere else.
Right.
Not because it came from Page, but
right,
because
and you said
it was filed in Coconino County.
Right, and it needed to be filed in Coconino County because the rationale was notice to the judgment debtor.
We didn't say that because the judgment that J.C. Penney got came from Page. That meant that the only place they could have filed it, the judgment was in Coconino County, and therefore the renewal has to be in Coconino County. We said the renewal was no good because this judgment was filed in Coconino County.
But what this court did say in paragraphs 20...
About the notice, we certainly did. But then when we come down to cutting the nut, we say, here's the reason. It's not because you filed it in Maricopa County instead of doing it in Pinal County. We're saying it's because...
Right, and I don't dispute that the facts are different here. They TJ'd it in Maricopa. Ironwood Commons TJ'd it there. They did not TJ it in Coconino. That's the different fact here. But the act of TJing it doesn't give any of this notice rationale that the court required in paragraphs 29 and 30.
I'm just saying, if we tell you the reason for what we're doing, and it has nothing to do with where the judgment emanated from initially, then this case doesn't really stand for much of anything with regard to what we're looking at today.
Well, I think the rationale in the paragraphs 29 and 30 needs to be extended
I totally understand your
to the
argument.
facts here.
I understand about the rationale. But either we ignored the rationale when we got to the conclusion, or the conclusion is just incorrect.
I mean, the conclusion was it was inapplicable because they TJ'd it in the proper county. And they just did the affidavit in the wrong county.
But we said the reason the renewal's no good is because the initial judgment was filed in Coconino County and it has to go there. Not because it came out of Page, but because that's where you filed it. That's what we said.
And the underlying facts are different because
True.
Had they done the TJ in Pinal County, J.C. Penney would stand for they had to do the affidavit renewal in Pinal County. And I know I'm over time now. If I could request just maybe a minute or two for rebuttal after counsel
Yeah,
goes.
we'll give you some time. Thank you.
Thank you.
Presiding Judge Jones, Judges Brown and Thompson, may it please the court. My name is Austin Valio, and I represent the appellee, Ironwood Commons Community Homeowners Association, Inc.
How about starting off by telling us how we're supposed to define proper court?
The legislature has already provided its intent in the other statutes, and this court in J.C. Penney clearly defined what proper court meant. I'll start with the legislature. If we just look throughout the rest of the statute, section 12-1612, you go to subdivision D, it explains again, the filing of the affidavit in the office of the clerk of the court where the judgment is entered and docketed shall renew and revive the judgment.
Does where it is renewed and docketed give us a specific county, such as the county in which the judgment was initially entered, or taken, where the judgment was initially taken? How do we know that we're supposed to file it, according to opposing counsel, in the same county in which the judgment was given?
Had the legislature intended that, they would have stated that, as they aptly proved they could do in ARS section 22-245 and 22-246, the execution statutes mentioned earlier, where if you're going to execute a levy on real property, you have to first do it in the county where the judgment was given. None of that type of language is in ARS 12-1612 or 12-1613. the affidavit of renewal statutes. And again, this statute is specifically to renew Superior Court judgments. However they came to be Superior Court judgments, whether it was originally entered there or upon a transcript of judgment from some other court. That's stated in subsection A. So the proper court to renew a Superior Court judgment is where that judgment happens to be docketed and entered. Again, in section 12-1613, both in subsections A and B, it says the word docket a bunch of times. Where the judgment is docketed, where the affidavit of renewal must be docketed.
I thought at the beginning of this argument that we established that the challenge was not to where this transcript of judgment was initially docketed. Did I mishear that? I mean, in the course of these proceedings, have the appellants challenged, or has the appellant challenged the fact that you filed it in the first place, not in the county in which the thing emanated from?
No, Your Honor. That would be a venue argument that they waived in the trial court. They never raised it, and the lower court specifically...
So then that puts me back to what sounds to me like a non sequitur in our opinion in JCPenney versus Lane. Because in paragraph 30, it sounds like we're adopting the notice principle that the appellant wants us to act upon. That is, you shouldn't allow renewal of a judgment in another county, because then that forces the judgment debtor to search all the county records of all the different counties in the state of Arizona. But then our conclusion isn't that you have to renew the judgment in the same county from which the initial rendering court is. It says you have to renew it where the Superior Court judgment has been docketed.
There's a simple explanation.
That's a non sequitur, isn't it?
Well, notice was provided in this case.
Right.
If you look at this court's analysis in paragraph...
If the reason for our holding in JCPenney is notice, then why did we say the renewal's fine as long as you filed in the same court you docketed the Superior Court thing in?
My explanation will harmoniously put those two provisions together.
Please, go for it.
Judge Grant would be happy to have it reconciled.
Paragraph 30, where this court analyzes the notice provision, and I'll read from it. It says, judgment debtors and other interested parties are able to check the status of the judgment at 5-year intervals following entry of the judgment by checking the records of the Superior Court Clerk's office in the county in which the judgment was recorded. We recorded this Maricopa County judgment in the Maricopa County Recorder's office.
But they don't know that. His argument is they know that there's a judgment against them because they were there. They know that much. They had notice of that. And they know that if they look at the law, they know it's good for 5 years. What they don't know is if after 5 years they're still on the hook. And what we said there was, oh, well, we need to read this in a way that effectuates to the most we can the judgment debtor getting a chance to find out if they're still on the hook after 5 years. But then we say, all you have to do is renew it in the county where you docketed, but if the debtor doesn't know you docketed Maricopa County, then they're not getting any notice from this procedure.
By recording it with the county recorder's office, they have now been given constructive notice that that judgment has been recorded in that county.
Yeah, for sure, but in paragraph 30 of this opinion, we said, yeah, but it's onerous to make them look at all the counties.
Other than those counties in which the judgment has been recorded.
But they don't know it's filed in a county other than
in today's world? What's the practical difference? Right? You can go search Superior Court dockets, and I mean, are you saying it's easier to search a recording, the public recording, because you go to the tile company, or is that the rationale there?
So, an example of an interested party that might...
No, you didn't write this opinion, so it's not really your problem to fix it, but it just seems there's an internal issue here.
And the way I'm trying to interpret it and argue is, for example, a lien holder or a lender wondering if Miss Randall is credit worthy. It will check the county records to see if there's a judgment. It may check her credit report, credit reports often check county records to see if a judgment has been recorded.
Superior Court records and Recorder's Office, you would assume.
Presumably.
Okay.
But at least they would check the county recorder's office, right? They would see that a judgment has been recorded in Maricopa County against Ms. Randall. That would then give them, under this paragraph 30, the obligation to check the court clerk's records in Maricopa County to see if that judgment has been renewed. We recorded this judgment in 2014, 2 years before the affidavit of renewal was actually filed. That gave Ms. Randall 2 years of constructive notice under ARS Section 33-416 that this judgment had been transferred indeed to Maricopa County.
And your argument would be exactly the same if they went and filed it, if your client had gone and filed it in Greenlee County in Arizona. It doesn't matter.
Because Section 33-962, the transcript judgment statute, specifically says that this is a procedure to help you record your judgments. So you get a TJ number, at least in Maricopa County. They do different numbers elsewhere. But you get that transcript of judgment for the Superior Court that lets you then record it with the county recorder, which would then provide notice to all the world that that judgment is now a judgment in that specific county, which then allows them to check the records of the Superior Court clerk in that county whether or not the judgment has been renewed.
Counsel, I got a question for you. Other than them, I have a question for you too. Is there a statute? We know that in order to be able to collect against a judgment on real property, you have to record the judgment and any renewal of the judgment to keep it current in the county in which the real property is located, right?
Correct.
Is there a statute? Is there any portion of the statute? Is there a nuance in a statute that says that if you get your judgment in Coconino County, but the real property is in Mojave County, you must first record the judgment in Coconino County and then subsequently go file it in Mojave County? Is there anything that says this is a tree and the branches of the tree? You have to get to the top of the tree trunk by recording it in the county that the judgment came from, and then branch out into any other counties where there might be real property?
There is no statute or case law that supports that position.
Well, here's what we said in J.C. Penney. Arizona law requires that before property may be levied or sold to satisfy a judgment, a certified transcript of the judgment must be filed in the office of the clerk of the Superior Court of the county where the judgment was given. So that's what we said there. So if that's accurate, then we said in Penny's, if you had intended to go after real property, you would have first had to have filed it in the Superior Court in Pinal County.
That's true. And that's
It's a little weird if there's no real property in Pinal County, and let's say there was real property in Maricopa, it would seem to make more sense to have you file it in Maricopa County where the property is. But if that's correct, you literally would have had to file it in Pinal, and I don't know. Can you file it again? Can you file it in all the counties if you want to? I don't know.
so this is an execution statute, specifically designed for real property, to levy on property. And the legislature showed that it knows how to draft a statute that would require this requirement to first record in the county where the judgment was given. They didn't do that when they drafted the affidavit of renewal statutes. So if you're simply just trying to renew your judgment, which is a process you have to do every 5 years and now perhaps every 10 years, you just follow the affidavit of renewal statutes. You don't have to then jump through the hoops created under these execution statutes simply to be able to renew your judgment.
But you didn't. You didn't file the initial judgment in the county in which the matter arose.
Because we weren't trying to levy on real property.
So that's only as to real property.
Correct. That's what that statute is designed for.
And so you did file, in J.C. Penney, they filed initially in an out county, if you will. I guess you only get to use the term out county in Maricopa County, right? You could get your judgment in Cochise County. Let's make them as far apart as we can. Go up and file your
transcript.
Record your judgment in Mojave County. Is there a necessary county, given that the judgment starts out in Cochise, The judgment it's recorded in Mojave. Is there a necessary county under J.C. Penney's in which you would have to file the renewal?
And under J.C. Penney, this court, in paragraph 27, again, looking at, after reviewing the statutes I've mentioned, 12-1612 subsection D, 12-1613 subsections A and B, came to this conclusion. The only conclusion that can be reached from reading these provisions in the renewal of judgment statutes is that the affidavit is to be filed with the clerk of the Superior Court in the same county in which the judgment was docketed.
Okay, so you got the judgment in Cochise, you docketed it in Mojave. You can't simply go back to Cochise and do the renewal.
Unless you then docket the judgment in Cochise again.
And isn't that what J.C. Penney stands for? Isn't that concept right there what J.C. Penney stands for?
No. The court never said you have to docket it anew in the county where the original judgment came from. It just says where it is docketed.
Which would be Mojave.
Which would be Mojave.
Okay, so you couldn't go back to Cochise because it wasn't originally docketed there, right?
Well, the court never says, it just says where it is docketed. So had we, for example, done a transcript of judgment in Pinal County and Maricopa County, we have now two judgments that are docketed in two different counties. All we have to do is file an affidavit of renewal in one of those counties, not both. It doesn't specify the county where the judgment originated from. It just says in one of those counties. And then, pursuant to 12-1613E, all you have to do is take the certified copy of your affidavit of renewal from one county, file it in the other one, and you now have both judgments that have been renewed. That's what 12-1613E stands for. Not that you have to do it in the county where the judgment originated from. Those words are never spoken by the legislature in any of those statutes. Those words were never spoken by this court in J.C. Penney versus Lane.
How broadly do we interpret just the Superior Court in those statutes? It must be recorded in the Superior Court, right?
Correct.
How broadly do we read that?
Well, this court narrowed it to where that judgment is docketed. So it can't be docketed in Mojave County.
We may have thought we were narrowing it, but isn't that what the 1612D says? Like we were just applying.
Right. That's what section 12-1612D says.
We applied the statute directly, but then we provided all this notice rationale that doesn't seem to even apply.
Well, again, not to rehash the argument, I think I stated it before, but I do think notice is provided even though it's not actual notice. Actual notice is actually...
Constructive notice you're talking about.
Correct.
But in paragraph 30 of J.C. Penney, we were clearly talking about the burden that would be put on judgment debtors by requiring that they check all the counties instead of the one that they know where the judgment came from.
Well, that's not the language that you used in paragraph 30. The language that you used was they know to check the records of the county where the judgment's been recorded.
But they don't know where the judgment was recorded.
Well, they have constructive notice. And actual notice is never required, not under the statutes or under J.C. Penney versus Lane. So constructive notice, which would require them to go scour records of the clerk superior court for an affidavit renewal, is all that's required, and they get that.
It talks about judgment debtors and interested parties actually checking the status of the judgment, not having imaginary constructive notice that the thing is still has vitality.
If they had actual notice, they wouldn't need to go and search county records, right?
Turning to paragraph 28, which in J.C. Penney, our court appeared to reject the notion from the Arizona Constitution that because the Superior Court is defined as a single court, there's only one Superior Court, appeared to back away from that and say, no, that's not going to control here. But the last sentence causes me some concern, or some adds to the uncertainty. I think it said, so too would uncertainty and confusion about the status of cases reign if we held that legal documents such as affidavits for renewal of judgments could be filed with the clerk of any county of the Superior Court, regardless of whether that county of the Superior Court has any connection with anything else about the case or judgment involved. Why is that a warning shot? Is that dicta? Because they're saying right there, confusion would reign if we're going to allow a Pinal County judgment in Pinal County Justice Court to be filed in Apache County. Confusion would reign. That's what they're saying right there. Am I misreading that?
Well, I think the facts of the case explain this comment, which is the judgment had been docketed in Coconino County, and then the affidavit of renewal was tried to be filed in Maricopa County. Maricopa had never even docketed the judgment. They don't have any records of the judgment. They have no clue what this affidavit of renewal is supposed to be for. It doesn't even have a Maricopa County case number.
So your point is the transcript of judgment under the transcript of judgment recording statute allows it to be filed in any of the 15 counties.
Correct. And under that statute,
And then, once you've established a docketed judgment, then you can presumably file an affidavit of renewal. That's your argument.
that is our argument. Because you're doing, presumably, once you transcribe it there, you're going to be levying on wages like we did in this case. You may be filing things in that court. And then, once your judgment's about to be expired, you would renew it in that same court. So it's not just a singular event of transcribing the judgment there and then a singular event of the affidavit of renewal being filed there. Presumably, you would have activity in the case like we did in this case. And briefly, I want to talk about the attorney's fees argument that they advanced in their appeal. And primarily, I just want to mention that their motion to vacate had two grounds on it. One was that the judgment was void for lack of renewal, which we've discussed at length. The second was that the attorney's fees shouldn't have been awarded because the judgment shouldn't have had a term in it that allowed for post-judgment attorney's fees.
Well, it seems like it's pretty prospective. Can you enter a judgment for fees that haven't been incurred yet?
Well, the Justice Court put that in the judgment, right? The Superior Court...
It wasn't appealed, apparently.
Correct. And the Superior Court lacks the jurisdiction to vacate that portion of the judgment. That's stated in the case of Marquez versus Perez, where some default judgments were entered in the Justice Court, transcribed to the Superior Court, and a motion to vacate was filed in the Superior Court. And Division 2 of the Court of Appeals said, although the judgment is a statutory judgment through the transcription process, it doesn't confer jurisdiction and authority of that court to amend or vacate that judgment. And so if they had intended to appeal or vacate or strike that post-judgment attorney's fees provision out of the judgment, they should have done that in the Justice Court.
Because it's an interesting concept, because the Superior Court would be the appellate court also. The Superior Court would have had appellate jurisdiction to determine whether that fee provision was appropriate.
Correct.
But apparently not, according to Division 2, not based on the
Original jurisdiction.
Counsel, let me ask one quick question, if I may. Are you ever aware of any statutory authority under which the non-record court was entitled to award attorney's fees? Is there an attorney's fees basis? Is there a statutory entitlement for the court? 12-341-01 is the one we always think of, right?
Right.
Is there statutory authority for the Justice Court to have entered a fee order in this?
Not that, other than 12-341, I don't know.
The judgment
The
contract?
contract certainly had a provision in there about attorney's fees, and given the merger doctrine, that provision could have been merged into the judgment, which would allow the court to include it as a provision in the judgment. But the fact is, those types of arguments had to have been made before the Justice Court where the judgment was entered, not the Superior Court, because it lacked the jurisdiction to alter that judgment. And because the judgment itself was sufficient authority for the Superior Court to award fees, this court should uphold under Bennett Bloom that award of attorney's fees and the denial of the motion to vacate.
Thank you, counsel.
Thank you.
Counsel, you got 2 minutes.
The first point I want to respond to is ARS 12-1612D. And in that statute, it says that the filing of an affidavit in the office of the clerk of the court where the judgment is entered and docketed shall renew and revive the judgment. A TJ proceeding is not the entry of a judgment. The entry of the judgment here occurred in Pinal County through the Casa Grande Justice Court. The TJ proceeding is just the docketing. This statute doesn't say the filing of the affidavit of renewal in the court where it's docketed. It says where it's entered and docketed.
But then the clause says whether originally rendered by it or entered.
That's under 33-962, I believe you're referring to.
No, that's language under 12-16-12. Whether originally rendered or entered upon transcript from another court.
In subsection A?
Yes.
Yes.
So how was that?
You can renew the judgment wherever you've docketed it, whether it came from that court or you brought it in from some other court, but that renewal still is modified by the last sentence that it has to be done with the clerk of the proper court.
What about the clause right before it may be renewed? What about, it says, or recorded with the county recorder? That seems to be hanging all by itself. What does that mean?
Well, recording the judgment with the county recorder is different than
No, but
filing it.
we're talking about renewal.
Right, a judgment that has been docketed for the purposes of execution, getting writs of garnishment or judgment debtor exam, or a judgment that's been recorded to get your judgment lien, either of those can be renewed by filing the affidavit in the proper court.
So you're saying this judgment couldn't have been renewed?
No, you need to TJ it in the Pinal County Superior Court, because that's the county where it was entered. And then you need to docket it there also. And then you go to 1613E, which says when you do that affidavit of renewal.
I thought we started this argument with you telling me that you were challenging the propriety of the initial docketing of this judgment in Maricopa County.
Take that Casa Grande Justice Court judgment and docket it in any county they want. And I don't challenge the docketing there and the recording of it in Maricopa County. If they thought she had property there, that's what you do. But execution, such as TJs and getting writs and judgment liens, execution is different than renewal. And I think we're conflating the two issues here, and they need to be treated separately. The legislature treats them separately.
Right, but if this thing was docketed in Maricopa County but not entered in Maricopa County, then it can't be renewed under 1612D according to your reading, right?
No, correct. It can't be renewed in Maricopa County.
By asking you, are you saying this can't be renewed? And you said, no, you weren't saying that, but I think you are saying that.
No, it can be renewed, but it has to be renewed in Pinal County.
How
They
can
could
it be
docket
renewed?
it.
The judgment's not entered and docketed in Pinal County.
That's a step that the judgment creditor needs to take.
But they didn't.
And that's why any other efforts to
If I asked you, is your position that this couldn't be renewed? You're saying it couldn't be renewed because they didn't docket in Pinal County in the first place?
then let me amend.
I'm
change.
trying to understand the logic of your argument.
Right. The logic is it needs to be renewed in the county where it came from, because that's where she has notice of that the proceedings are going on. And the procedure to do
that
that
would be consistent with what Judge Grant said in J.C. Penney in paragraph 30 about notice, because that way the debtor would know there's a judgment. They would know that it's valid. It's been docketed in Pinal County, and all they need to do is check Pinal County. It's not consistent with Judge Grant's conclusion in paragraph 33 that you can renew it just by filing where you filed the transcript to whichever Superior Court you filed the transcript in.
Well, and I don't think he's stating that it's whichever Superior Court you filed the transcript in, because in Penny they filed the transcript in the county where it originated from. So they're dealing with the specific facts there. We have different facts.
If the judgment was a Coconino County Superior Court judgment, the affidavit of renewal was not effective unless filed in Coconino County. So,
which is where
if
it was
a
entered
Maricopa
and
County
docketed.
Superior Court judgment, the affidavit of renewal was not effective unless timely filed in the Maricopa County Superior Court. This seems to me that we have a conflict between our notice rationale in J.C. Penney and our conclusion.
And I think the different facts here, when you apply that rationale, would lead to the conclusion it needs to be.
And I understand your argument. Your argument starts off by saying that it was not proper in terms of later executions or renewals for the creditors to have failed to file the transcript in Pinal County in the first place.
Correct. They needed to docket it there and renew it there, and the statutes provide for that. Thank you.
We do appreciate the argument. It may be a very circular argument in some ways, but we do appreciate the time you spent with us. We're going to take the matter under advisement in this time, and we'll certainly issue our decision in due course. Thank you.
Thank you.